lecture. And I wish you all a very happy Ambedkar Jayanti and a very happy Vaisakhi, and also a million happy New Year. And before we start the lecture, I would request Mr. Jaideep Gupta, Ms. Nandini Gore, and Mr. Vikas Singh, Mr. Rajiv Datta, and Justice Narasimha to kindly come on the stage. So we have gathered today here to celebrate life of Mr. Soli Sorabjee. We are here to celebrate his legacy, and he was an extraordinary jurist, a champion of human rights, and apart from that, we all discuss about work-life balance, but one thing that everybody discussed about him was his avid reading of literature and his passion for jazz music. So it's very important for us to keep alive the memory of those who have inspired us. And as Cicero said once, that the dead often meet on the lips and in the memory of the living. So before we proceed, allow me to briefly revisit his life. Soli Sorabjee was born on 9th March 1930 in Bombay. His journey in law began in 1953, and by 1971, he was designated as a senior advocate. He also was a senior advocate arguing the famous Kefanandan Bharati case. Over the decades, he emerged as one of the foremost constitutional lawyers of the country, appearing in several landmark cases that shaped the contours of governance and civil liberties in India. He had the rare distinction of serving twice as the Attorney General from India from 1989 to 1990, and again from 1998 to 2004. His contribution to the field of law was also extended beyond the courtrooms. In 1997, he was appointed by the United Nations as the Special Rapporteur for Nigeria, and later served as the chairman of the UN Subcommission on Promotion and Protection of Human Rights. In recognition of his immense contribution, he also was awarded the Padma Vibhushan in 2002. So before we move towards today's lecture, I would request my colleagues from Nivaaran to present the planters to our guest today. I would request Mr. Akash Shankar to present the planter today to Mr. Vikas Singh. Senior Advocate. Now I would request Mr. Uday to kindly present the planter to Mr. Jaideep Gupta. Now may I kindly request Mr. Keshav to come and present the planter to Justice Narasimha. I would now request Ms. Dr. Vinay Ahuja of the Mohan Law House, who is supporting today's event, to please come forward and present the memento to Justice Narasimha. Memento.
Thank you.
So the theme of this year's lectures is very important and is very topical. Human rights in the empire of artificial intelligence. It is very timely and important, and it is very important for the reason that today we see every day on reels, on internet, where there are misuse as well as use of the AI, where ChatGPT is being used quite heavily, and then we also see that there is a delegation of the human judgment to be made by AI. So somewhat earlier when we were studying, we would use Google to guide us, but now when we see people, young students using AI, it is the AI that is driving them how to work. So it is a very topical issue, and we are glad to have Justice P.S. Narasimha to discuss this lecture today. And artificial intelligence is no longer a distant concept. It's deeply embedded in our everyday lives, from decision making in finance, employment, healthcare to growing presence in legal research and adjudication. AI is shaping both human experience and institutional processes. So even within legal professions, courts have cautioned against uncritical use of AI tools, the delegation of human judgment to automated systems without sufficient checks poses real challenges to the fairness and justice. This makes today's discussion not only relevant but necessary. And I'm sure Justice Narasimha will reflect upon this intriguing question of law. But before we proceed further for the lecture, I would now request Mr. Jaideep Gupta, Senior Advocate and also the Council Member for the Commonwealth Lawyers Association representing India, to come and share his insights and reflections on Mr. Soli Sorabjee. Thank you.
Good evening, everybody. It's the 5th lecture, and we are, of course, running out of things to say about Soli. He was referred to, today I found that he was referred to in a foreign newspaper as the philosopher jurist of India. This is a wonderful way to introduce him, because obviously he was a jurist, but his special quality was that he never approached a brief with any narrow sense of purpose. It was always with a wider understanding, a wider sense of purpose. A career which spanned 6 decades, during which he shaped in significant ways the Indian constitutional law. The 4 great judgments which owe something to him are Keshavananda Bharati, Maneka Gandhi, as Dr. Manish Singhvi just mentioned, one of the members of Mr. Sorabjee's chamber. The other, of course, is Mr. Ganesh, who would have been able to tell us a lot more about Soli. Manish mentioned that Maneka Gandhi was his favorite case. Then there is S.R. Bommai, and very recently Shreya Singhal, where in all these judgments, something which is fundamental to all these judgments is his emphasis on the freedoms, the freedom of speech, the freedom of the press, the freedom to speak online, and to protect the federal structure of the Indian Constitution. He was, in his day-to-day practice, his favorite subject was indirect taxation. And I had the good fortune of working with him on a large number of indirect taxation matters, and he was a teacher par excellence as far as that was concerned as well. As you know, he entertained us by writing columns in the newspaper every few weeks. He was also a prolific writer. He wrote on the law of press censorship, on the freedom of press as a fundamental to a functional democracy. His footprint across the world is unique amongst Indian lawyers. Only very few have got such recognition in the field of human rights across the world, which we see from his work on Nigeria, which we see on his work as in the subcommission for promotion and protection of human rights, etc. He was a member of the Permanent Court of Arbitration for a while. Today, being Ambedkar's birthday, I was interested to find that in one of his writings in the Indian Express in 2019, he wrote about Ambedkar saying the following, that Ambedkar ji attached great importance to constitutional morality. This is a topic which is very alive in the constitutional courts of this country today. But what he meant by it is a little different from what we today think about it. He went on to say that Ambedkar ji, by constitutional morality, meant a paramount reverence for the forms of the Constitution, enforcing obedience to authority acting under and within the limits of these forms, yet combined with the habit of open speech, of action, subject only to definite legal control and unrestrained censure of those very authorities as to all their public acts. So, constitutional morality, as far as Ambedkar ji was concerned, was the duty of constitutional authorities. And he went on to say that it was not a natural sentiment, it had to be cultivated. So, as I said, I've had the privilege of working with him on private and government briefs. His style of working, as many of his juniors will tell you, was very informal. He used to often entertain us in his book-lined study, put his feet up on a table in front of him, and write on the back of the brief. Yet, out of those small scribblings would come a precise formulation in court. The submissions were never long, and they were always with great clarity, and nobody came away after listening to him that we didn't understand what he said. That is the hallmark of true advocacy. With these words, I would like to invite Mr. Vikas Singh to speak briefly.
Honorable Justice P.S. Narasimha, Judge Supreme Court of India, Mr. Jaideep Gupta, Ranjani Gore, Rajiv Datta, Siddharth Sijoria, distinguished guests, fellow members of the bar. It's too much of a coincidence that yesterday we had the 4th memorial of Justice Lecture of Shri Ashok Desai, and one day later we are having the 5th memorial lecture of Mr. Soli Sorabjee. And I was the president of the bar on 10th of December 2021, when I had the privilege of doing the full court reference of both of them on the same day in the Supreme Court. Both of them, of course, were legends. We are, of course, here to discuss the empire of artificial intelligence, but we are doing so in the shadow of a man who was the ultimate human intellect. When we talk of Soli, there is a tendency of getting lost in the titles of his being Attorney General, Padma Vibhushan, etc. But Soli wasn't the title. He was a force. If you briefed him, like I first did in a matter of Rajasthan spinning and weaving mills, in excise matter, I didn't go to explain the law to him. I went there to see if I could learn something in that briefing. I remember that briefing vividly. He had all the facts. He asked me only 2 questions, and exactly the same 2 questions were asked in court. He had the ability to make legal knots into a straight line. We are entering into an era where AI interdependence is inevitable. It will research, it will draft, it will give you answers in seconds. But there is a trap, the fallacy of the infallibility. Because a machine gives you a fast, polished response, you start to believe you're always right. You stop doing the heavy lifting. But as Soli showed us, knowledge retention is useless without human application. Soli just didn't store law, he internalized it. He was not just a student of law, he filtered it through a lifetime of jazz, poetry, and uncompromising love for liberty. This wasn't just academic for him. During the emergency, when the right to life itself was suspended, Soli didn't look for an exit. He stepped up pro bono activity to defend political prisoners held under the draconian MISA. He knew that when the state's throat is at the citizen's neck, a lawyer's only job is to stand in the way. What truly set Soli apart was that his courage didn't disappear when he was given power. Even as the Attorney General, he maintained a fierce independent will. He saw himself not as a government mouthpiece, but as a counsel for the Constitution. Look at the legal minds he cultivated through his mentorship. He just didn't pass on files, he passed on standard of erudition. He mentored Justice Lalit, Harish Salve, Dr. Singhvi, Gopal Subramaniam, Mr. Ganesh is here, Anand Haksar. These names dominate our courts today because they learned that you don't choose this profession to make money. You choose it because of interest and because you have that interest in getting justice. If you chase money, you're not just a technician, and a machine will eventually do that better. If you chase interest, you become a jurist. I had the opportunity of working in close quarters with him in the TMA Pai Foundation, where the Supreme Court was shaping the early contours of minority education rights. In Rupa Ashok Hurra, which crafted the curative jurisdiction to prevent miscarriage of justice, and the Natural Resources Allocation Reference, which clarified the constitutional principles governing the state's allocation of natural resources. If I were to rely on AI for the same, an algorithm would have looked at the rules and given a cold, logical answer. But Soli looked at the spirit of the nation. He understood that a law without a soul is just an instrument of oppression. He famously said, tolerance cannot be legislated, it must be fostered. You cannot program a culture of tolerance into a machine. You have to defend it in the courts. Soli's work was never limited to India, whether it is a UN rapporteur for Nigeria or the Permanent Court of Arbitration at Hague. He took a brand of human rights to the world. He understood that right to dissent is the sine qua non of democracy. To the youngsters here, AI is empowering, but it shouldn't make you arrogant. Standing on the shoulders of a giant like Soli means using the height to see the human nuances that a machine will always miss. He lived up the words of William Hazlitt, the soul of a journey is liberty, perfect liberty, to think, to feel, do just as one pleases. As we hear Justice Narasimha navigate the complex intersection today, let's remember, Soli is not as a figure from a textbook, but a reminder. Know how much advanced our empires of technology become. The protection of human right will always come down to a single human being having the courage to stand up and say, this is wrong. Soli stood up for that. Thank you.
Thank you, Jaideep sir and Vijay sir, for this interesting reflection on Mr. Soli's life and also sharing the insights on AI and the use of it in the present time. Now I will request Ms. Nandini Gore, Senior Partner Karanjawala and Secretary Nivaaran, to please introduce our distinguished chief guest to the audience.
Thank you, Siddharth. When we speak of human rights in the age of artificial intelligence, we must anchor ourselves in constitutional wisdom. Few embody this wisdom better than Honorable Justice Mr. P.S. Narasimha, a distinguished alumnus of Campus Law Center, whose journey from bar to bench reflects an unwavering commitment to justice, accountability, and the rule of law. Before his elevation in 2021, Justice Narasimha had a remarkable career as an advocate. He was designated as a senior advocate in 2008. He was appointed as Additional Solicitor General of India in 2014. He appeared in several constitution bench matters, from the Ayodhya title dispute to the NJSC case. He presented India before international tribunals for the law of sea in Hamburg, Germany, and he also represented India before the Permanent Court of Arbitration, Hague, investment treaty arbitrations. On the Supreme Court in constitution bench matters, his jurisprudence balances right with institutional limits. In Supriyo versus Union of India 2023, he reminded us of judicial restraint and the separation of powers. In Sita Soren versus Union of India 2024, he helped overturn precedent to affirm that no public office shields bribery, a virtual reminder as AI risks opacity in decision making. In NCT of Delhi versus Union of India 2023, he reaffirmed the chain of accountability in democracy. In Jaya Thakur versus Government of India 2023, he advanced dignity through directions on menstrual hygiene in schools. While researching his judgment from the year 2025-2026, I found out many landmark judgments on arbitration laws like mother agreement, contractual limit, forged arbitration agreements, and so on. The list is very long. His commitment extends to access to justice through the National Legal Services Authority. He has worked to ensure legal aid reaches the most vulnerable, because right means title little unless they are accessible. He is closely associated with the Supreme Court Mediation and Conciliation Project Committee. Today, Justice Narasimha also chairs the Supreme Court Artificial Intelligence Committee. Under his guidance, the court is embracing technology thoughtfully. AI tool transcribe constitution-based arguments, improving transparency. The court is exploring algorithm-assisted case allocation to aid of roster while keeping human control. The goal is consistency, fairness, prioritizing listing urgent constitutional matters. He has been equally clear about fake and hallucinated AI-generated precedents in trial courts, warning the unverified outputs which erode adjudicatory capacity. His caution that all our reliance on AI can dilute independent legal reasoning. AI must remain a tool, never a substitute for human judgment guided by the constitutional values. He also urges us to rethink contract law for an age of smart contracts and autonomous systems. The Indian Contract Act 1872 may need structural reimagination, but he notes law was always evolved with society and technology. It must do so again, but carefully. In the empire of artificial intelligence, technology can bridge divides or deepen them, leaving the marginalized sector further behind. Justice Narasimha's careers remind us that as we innovate, human dignity, accountability, and constitutional morality must lead. It is my humble privilege and honor to invite Honorable Justice P.S. Narasimha to share his vision on today's topic, human rights in the empire of artificial intelligence. Justice.
Sir, tell me.
That's good enough. That's good enough. Thank you very much, Nandini. Thank you for the introduction, long introduction. My esteemed brother, Prasanna Varale, so kindly has come for this conference. Mr. Vikas Singh, President of the Bar, Joydeep Gupta, Learned Senior Counsel, Rajiv Datta, Senior Counsel, Santanam, ever President, evergreen President, and Honorary Life President of CLA, Vipin Nair, President Skora, I forgot, sorry, excuse me, Learned Additional Solicitor General Anil Kaushik, Mr. Ahuja, so many of my friends here. And the time that we have, I will not be able to call all of you because we have a working day tomorrow and I know the time constraint. And it's a matter of great privilege to be delivering the 5th Soli Sorabjee Memorial Lecture, an occasion that honors the enduring legacy of a jurist whose life and works have profoundly shaped the constitution and human rights jurisprudence in our country. One unique thing about Sorabjee is that all those who knew him or those he knew always felt that he likes him very much. So I am one of those categories. And I felt that he liked me. And I'm sure everybody has that feeling. I think one incident, when I shifted to Delhi, I heard about him and I wanted to see him argue. So I came to know that he was arguing in court number 2. So I went and saw him there. And I looked for a chance to go to his office. So somebody was to brief him. I tagged along and went for a conference and saw him. Then I myself briefed him. I also appeared with him. I traveled to many high courts along with him. I appeared against him also in the later part of his life and times. One unique incident, I never forget about that. I think it was sometime in late 19s. I was just about 8 years into the practice. A lawyer from Patna got me a brief of a member of a legislative assembly who won the election but couldn't become a minister because late Bhutta Singh has dissolved the legislative assembly. So I filed a writ petition on his behalf and eventually the matter got referred to a constitution bench and it was listed for hearing on a Tuesday. And I was told that the main political party in opposition also had joined the batch of writ petitions. And I think at that time, Mr. Arun Jaitley told me that Soli is appearing. So everybody was quite excited. And I tried to contact him that weekend. I was told that Soli is in Pakistan. So we waited that weekend. And on Monday, when we were asking, we were given information in bits and pieces that coming by flight was difficult and that he is coming by road. And after some time, we got information that he just crossed the Wagah border and then he was going to Chandigarh. He is going to be lifted from there. And as Monday morning or Tuesday, we all assembled at 10 o'clock and waiting for him. At about 10:15, he arrived. And the excitement was so much that we all thought we won the case. The mere presence of Mr. Sorabjee. And then he asked a couple of questions. And when the court assembled, he started addressing the court, constitution bench. He said, "My lords, one of the greatest judgments this court has ever delivered is Kesavananda Bharati. There is no doubt about that." "Yes, Mr. Sorabjee, of course. There is yet another judgment, my lord, so important for democracy, so important for federalism." And he stopped. And then Justice Sabharwal said, "I'm sure you are talking about S.R. Bommai's case." "Exactly." Exactly. My lord, it's not enough to make precedents. It's not enough to make precedents. We must also follow them. And then he started his arguments, and the rest is history. You can read the judgment of the Supreme Court. I have great memories about my appearances. I had a very small brief, very small brief. So I was a little afraid of, I formulated 2 points. And then after his arguments and somebody else's argument, I started and I formulated the point and I started reading from the written note. So Soli was sitting just next to me and he said, I was anxious, I was tense too. He said, Narasimha, slow. And then I looked at him and then I couldn't control myself and I was again speeding up. Then he again said, Narasimha, slow. The judges are listening to you. You have a good point. Go slow. Then at his prompting, I mustered courage and confidence and slowly completed my submission. And that was my first appearance before a constitution bench. That's an incident which I can never forget in my life. And immediately after that, when the judgment came, Times of India reported that Soli has held a victory celebration in IIC. Really speaking, it was not a victory celebration. Soli doesn't do that. It is his usual. He has his regular parties. All of us have enjoyed the party. We have attended them any number of times. So such was the greatness of his capability to understand the court, put forth the point, the precision in his submissions. I see many youngsters who would not have seen him argue before the court. For them, there are few things. He served twice as the India's Attorney General and had important roles at the United Nations, becoming a respected figure in human rights circles around the world. His underlying philosophy regarding the role of the Attorney General was fundamentally rooted in institutional independence and constitutional morality. When he assumed office, he publicly declared that his primary duty was to act as a guardian of public interest and not as the government advocates at all costs. This philosophy was captured with great eloquence in a letter written to him by Nani Palkewala upon his appointment. I quote from his letter, "What you have said about the Attorney General's office as guardian of public interest and promoter of human rights is so true and so little understood. The greatest glory of the Attorney General is not to win cases for the government, but to ensure that justice is done to the citizens." Unquote. Considering the time and also considering the fact that many of you know him, a few other things I'll just indicate and then get to the subject. Soli's legal brilliance, in a curious way, is intertwined with his love for jazz. He himself drew the parallel explicitly, noting, "The essence of jazz is improvisation. In my advocacy," he said, "I don't make long page note. I make just 10-page notes. I prepare the case, argue in courts according to what the situation demands." Exactly, this is what he used to do. In his tribute, Gopal Subramaniam said, "Just as a jazz musician remains anchored to harmonic structure while improvising freely in response to movement, Sorabjee's appellate advocacy was marked by extraordinary forensic ability and careful preparation, paired with the ability to adapt in real times to the unpredictable demands of a courtroom." Unquote. He was not merely a great lawyer. He was, as Justice Krishna had said, a man of luminous advocacy, an architect of society who elevated law from a high art form. Soli stood for clarity in constitutional thinking. He combined intellectual rigor with a deep commitment to constitutional values and approached the law not merely as a profession, but as a public responsibility. It's a very important facet of his life. There's yet another thing. His advocacy was marked by balance and restraint. Again, yet another very important factor. And an unwavering faith in constitutional norms. Over a career that spanned 7 decades, he was a fierce defender of civil liberties and human rights, always standing up against the government when it sought to overstep its bounds. It is in this spirit and it is in this background of what we know, understand, and seek to emulate Sorabjee that this lecture assumes significance. The topic that I have chosen is a little difficult topic, so to say. Human rights in the empire of artificial intelligence. Not because of the theory of artificial intelligence, but perhaps because of the vocabulary of artificial intelligence and the jargon that we are not really used to. It's also a difficult topic for the reason that how it operates as a power is difficult to perceive, because you can't see the power as is exercised by the government when it is done through AI. It is invisible, and we don't have a lived experience of how AI would have affected us or would be affecting us. Another difficulty about AI is that it has a positive side of it. We are definitely the beneficiaries of AI. So that makes us perhaps ignore aspects which are impinging upon our freedoms. And you might be blamed, I might perhaps be blamed, or anybody who says about AI might say, you seem to be having an exaggerated conception of AI, or your fear is perhaps far-fetched. We need to balance it. My speech will indicate how it is balanced and what more needs to be done. I have ensured that we discuss about AI not in a jurisprudential form. Most of the writings are by Western authors, but I have entrenched it in our constitutional living and as it applies to our people, and try to deal with application of AI in real life situations. I think it's only in that context that we can really understand how AI is going to affect us and how it's going to be beneficial to us. I'll deal with the utilization of AI in the context of Article 39, when the material resources of the country are to be made accessible to people through welfare measures, perhaps. And what happens when these welfare measures get embedded with AI? I think you will understand that very easily. What happens to that accessibility? We will also deal with due process, which is so very important for all of us, particularly in the governance of law and order. The very important topic of privacy, of course. We have cartloads of jurisprudence on privacy. We will deal with current issues such as deepfake, something which is close to my heart, elementary education. Article 21A, what does AI do to it? It is in this contextual facts that we will be able to understand what are the challenges that we are going to face, those relating to profiling, those relating to exclusion, those relating to embedding of AI. Who has the burden if somebody is excluded or a human right is violated? Who has the burden to answer? Where are the remedies and how are we formulating our remedies? And who bears the liability? Extremely important in a situation of AI. who bears the liability? It is in that context, perhaps we will see that it may perhaps be necessary to reformulate not only the remedies or restructure the remedies, but also to formulate certain rights. Rights such as the right to explanation, data autonomy, right against AI discrimination, the obligation to correct. Who has that obligation to correct it? And I formulated this out of a principle that I was dealing with in the competition law. We perhaps need to formulate yet another principle, that is an ex-ante principle. We can call it a principle of inception. Before an algorithm is prepared and put into operation, it is at the very inception that the obligation to ensure that it doesn't violate any human right must exist. That is a principle of inception. And I will conclude with a very important facet, which I would say is related to the character of human being. That is, we all will be able to deal with it positively and get benefited out of it as long as we are 2 steps ahead of AI. If we let AI overtake us, then we lose very many powers that exist in us. I will indicate that in the course of, but be prepared that I might perhaps be reading and it might be a little boring when I read continuously, but it is inevitable and I can't really help it because this topic requires that the principles must be guided on the basis of precise formulations. So to start with, let me tell you that the human rights as a principle commenced when UDHR was formulated. When we speak of human rights today, it is worth recalling the making of Universal Declaration of Human Rights in 1948. It did not emerge in abstraction, but through a deeply political and negotiated process shaped by the lived histories of injustice across different societies. Representatives from several countries, including India, brought to the table their own experience of hierarchy, exclusion, and violence. The document that emerged reflected an attempt to articulate a shared moral baseline in the aftermath of several global crises. This history, I'm saying, is important because it reminds us that rights are not static. They are responsive to changing conditions and they evolve when new forms of power begin to structure social and political life. Artificial intelligence presents one such moment. If UDHR responded to the violence of war, colonial domination, totalitarian regimes, AI confronts us with a more diffused and less visible form of power, which is embedded in technological systems and operates through data and prediction and also automation. I deliberately use the term empire as the heading of the topic. It is, of course, symbolic. Empire of AI does not resemble colonial empires, princely states, or the empires built through conquest and territorial control. Yet, in a different sense, the empire of AI may be one of the most expansive in human history. It is not confined to geography. It does not recognize national boundaries and it operates across jurisdictions and with remarkable ease. Its reach extends to everyday life, shaping decisions, behaviors, and institutional processes in ways that are often subtle but deeply pervasive. Unlike earlier empires, its expansion is not marked by visible occupation, but by integration into systems that appear routine and indispensable. Now you ask a question on your mobile and do a small search. Nowadays, the answer is an AI answer, invariably. So therefore, it enters your life and it is so pervasive and it is insidious in a way. You don't really realize that so many things around you are actually existing which are operable through AI. The empire is also characterized by continuous evolution. Its successors are not political regimes, but increasingly sophisticated technological models. As we see, the development of AI can be understood in terms of two broad waves. The first consisted of systems designed to perform limited task-specific functions. The second, which we are witnessing, is marked by emergence of large language models, LLMs, such as ChatGPT, which are capable of learning from vast databases and generating outputs in ways that approximate autonomous reasoning. This shift signals not merely a technological advancement, but a qualitative transformation in how intelligence itself is produced and deployed within the emerging empire. So we have an intelligence which is surrounding us. Jokingly, I used to say that is it true that AI, with its mind of its own, is perhaps the Kalipurusha of the modern time? We don't know how it's going to build up and how it's going to be. But we see that there is a definite positiveness in that. It is in this context, as we engage with AI, the task is not merely to restate human rights in their existing form, but to examine how their implementation is being reshaped by these technologies, to confront the new challenges they pose, to consider whether this movement calls for the articulation of new rights and remedies responsive to these transformations. We know of administrative law as judicial control of administrative power. It is that power which is exercised by the government. The nature of power in the age of AI is distinct from earlier forms of human rights framework were designed to confront. AI-enabled power is diffused, no longer confined to the state, but dispensed across private actors, platforms, and technological systems. Human decision making to system-driven operation. And deep structural shift is from command to computation, and from identifiable responsibility to diffusion across networks of actors and technology. This is very important. AI does not displace power. It reorganizes itself in ways that are less visible, but no less consequential. So that power exists. So we need to deal with AI in the sense that it has that power embedded within. As of today, we know that it is in our hands and we completely control it. How it moves forward in a manner that the person in whose control it is would perhaps be saying that I didn't know that it was to operate in this manner. That is the reason why we need to deal with AI carefully and with complete control. In India, I would say that this transformation produces a set of concerns that are both acute and context specific. This is relevant for lawyers as well as judges. Article 39, as I was mentioning earlier, our constitutional mission of distribution of material resource, goods and service to subserve common good was undertaken exclusively by the state with somewhat partial success. As state turns to AI and digital infrastructure to improve efficiency in service delivery, a tension emerges between technological optimization and inclusive access. Across jurisdictions, institutions are increasingly relying on AI-driven platforms to identify beneficiaries, process claims, and distribute entitlements. The underlying assumption is that technology can enhance efficiency, reduce leakages, and enable more targeted delivery. In many instances, it's actually true. It has indeed improved administrative capacity, allowing governments to reach large populations with greater speed and efficiency. At the same time, this shift reflects a deep institutional transformation. Systems that were once dependent on layered human decision making, field officers, local verifications, and discretionary assessments are being restructured around automated processes and data-driven classifications. Institutions are, in effect, moving from relational to system-based models of governance. This transformation has a direct implications for human rights because welfare delivery is not simply an administrative function. It is central to realization of socio-economic rights. When access to food, healthcare, housing, or financial support is mediated through algorithmic systems, the design of those systems becomes constitutional significance. Error in data, rigid eligibility criteria, or failure to authentication can result in exclusion. The reality of this is seen in an instance where Aadhaar-based welfare measures such as LPG subsidy, Manrega, PDS food grains were administered through synthetic process of data, having disproportionately excluded certain manual beneficiaries due to biometric failures. It is also reported by state governments a welfare measure using machine learning for fraud detection has somehow excluded genuine beneficiaries. So it was offered to the state government that this is a very good scheme, and the best way to ensure that those who are ineligible can be kept out of the scheme. And we have developed a beautiful LLM, a model, and that model operated in such a way that not only that it excluded those, but those who are actually beneficiaries were also excluded, who were entitled to were also excluded. What happens when such an application is brought to the court, or can it ever be brought to the court is the question. I will deal with that in a little more detail. Many of you can really appreciate how such application of AI can exclude people. Take, for example, we are day in and day out dealing with competitive examinations like NEET, and we deal with CLAT examination and TET for that matter. So there are preliminary examination to the IAS, large number of contestants. So therefore, it's so very difficult. So you can employ AI for the purpose of assessment. When this assessment takes place, the algorithm which determines the cutoff mark or the answers would operate in such a way that it gives you a result in which if some could be excluded, and on what basis could one go to the court is a question. Take, for example, though it's not a human rights issue, Mr. Vikas Singh comes before us in a number of matters relating to electricity. Tariff determination. Tariff is not a human rights issue, but tariff determination is a complicated process. And there are now AI tools which will take into account multifarious factors for determining the tariff. And if those tariff determination models are so formulated that it eventually increases the tariff to such an extent that a common man for whose purpose Electricity Act is formulated will not be able to afford it. So those will be invisible for us to see. While the adoption of AI in governance reflects an effort to strengthen institutional capacity, it also requires careful constitutional scrutiny. The reliance on AI in governance, whether in welfare distribution, identification systems, or administrative decision-making, must therefore be approached with caution. In a society marked by significant digital divide, many citizens may neither fully understand nor effectively navigate algorithmic systems that determine their entitlements. There is yet another facet which I want to place before you that relates to due process. I've dealt with how AI could, in times to come, when it is fully employed, affect the goods and services that are to be distributed. Now, the declaration of due process, that procedure depriving a person of life and personal liberty must be fair, just, and reasonable, is not a technical requirement. It is the very essence of justice. This constitutional edifice now faces a profound test with integration of AI into governance of law and order. Many AI systems, particularly deep learning models, function as black boxes. They take inputs and produce outputs, but the intermediate, that is in between, steps are not intelligible to human observers. Even those who build these systems often cannot explain why a particular input produced a particular output. That opacity sits in fundamental tension with our judicial requirement of a reasoned decision. The principle of explainability in algorithmic decision making is closely tied to the foundational requirement of due process, natural justice, and non-discrimination, all of which require that individual impacted by the decision must be informed of the reasons behind it. Without transparency, affected individuals, this is so true, cannot contest or seek remedies against unjust or biased decisions made by the system. The guarantee of due process must therefore be extended to algorithmic processes. The right to know the case against one requires the litigant to be able to challenge AI-generated risk assessments or recommendations, which become impossible when systems are shielded as trade secrets. Procedural due process demands transparent, comprehensible decision-making mechanisms. AI system employs neural networks or deep learning that generate accurate predictions without explainable reasons paths. Absolutely accurate decisions will arrive, but you would want to know that how did you arrive? It is impossible to know, and that is where it affects. This is not, so to say, technophobia. It is, one should say, a constitutional fidelity to know how you arrived at a decision. The path forward must include a legally enforceable right to algorithmic transparency, mandatory disclosures of any AI-generated inputs considered by the decision making. Every decision that affects us, if it is brought to the court, so the respondent defending it has to explain it to the court. Even if notice is not issued, the court will ask for its satisfaction. Let's now deal with yet another issue, privacy, how it's going to affect us. In Puttuswamy, we have held that privacy includes decisional autonomy, dignity, and informational self-determination, and individuals' control over the disclosure, use, and circulation of personal data. This judgment, in many ways, is ahead of its times, and yet even Puttuswamy court could not have fully foreseen the scale of data extraction that AI systems would enable. Today, we live in an environment of pervasive collection of data. Every digital interaction, being every click, search, purchase, and movement, is recorded. It's all aggregated and fed into AI systems that learn to predict behavior, influence choices, and even shape lives. Privacy, therefore, can no longer be understood merely as secrecy or non-disclosure. This is very important. It must be understood as control over personal data and the governance of the complex infrastructure that process information at large scale. Digital Personal Data Protection Act has come in response to it. Let's see to what extent. There are certain gaps. I was just going through the act, and that's the Parliament's response to the difficulty of collection of data. However, the act does not fully grapple with deeper problems like inference, quote unquote inference. I will explain what inference is. AI systems do not merely process the data we explicitly provide. They collect data from our mobiles. It does not merely process it. They generate new data from old data. They take seemingly innocuous inputs such as your location, such as browsing history, social connections, and then infer sensitive attributes from out of that, because it would have collected large amount of data. So therefore, on that basis, it would start inferring sensitive attributes. It is inference, I'm quoting again, underline. It is not your statement, or it's not your volition, or it is not our likes or dislikes that we have displayed or said anywhere. It is the AI inferring on the basis of the existing data. So such inferences could be your religious convictions, political affiliations, health status, etc. It could even infer your vulnerabilities. It could predict your pleasures. It might also say where Mr. Vikas Singh is going to have his holiday next summer vacation. Because it already has the data as far as his existing profile is concerned. So therefore, these inferences were never expressly disclosed and never consented to. They violate the very premise of informed consent. The Standing Committee on Information Technology, in its 2024 report, has said, I quote, artificial intelligence and privacy observed that the absence of provision governing inference drawn by AI systems represent a significant gap in the legal framework. In fact, certain organizations have underscored the need to articulate a right to information audit, quote unquote, right to information audit, as a legal entitlement enabling individuals to demand transparency about what AI system has inferred about them and on what basis. Let's now talk of a problem that we are all facing that relates to deepfake, non-consensual, synthetic imagery disproportionately targeting women, perpetuating gender-based violence, and inflicting acute psychological harm. Our present legal framework responds reactively, but takedown comes after the harm has already occurred. The IT Rules 2021, as amended in 2026, impose mandatory labeling and expedited takedown underprivileged classes to be sitting with one of the posh schools in the country. That has not become a reality because naturally, for multiple reasons, it's the elite fight against the constitutional mandate, and it must become a reality, and that is what the courts would work towards. And there is a system by which these neighborhood schools are to operate, and they are being formulated. There's a website, and on which a poorest of the poor is expected to apply, and when he applies, and it is determined which is the nearest school available. It hasn't really worked, and we all know, we are not even surprised why it doesn't work. But that kind of a systems, in a large scale, whole of Delhi, for that matter, to be operable through a LLM or an algorithm, would have ways in which the allocation of students take place. So this is what is going to happen when one would ask. There was a case which came before me, but he says, this school is just next door, and I have not given a seat in that. The father came, of course, he came after a long time. But then this is what is going to happen. Tomorrow's cases before the court are cases of this nature, where entitlements, rights, are subjugated by technology or AI. And how are we as judges and you as lawyers going to deal with a situation like this and tell and get the remedies which the Constitutional Court has guaranteed to them? This is the real test for all of us, and my concern is about education. I will skip some paragraphs of it, and I'll tell you now what are the challenges before the court. I hope I am not exceeding the time. To cut it short, AI challenges to human rights relate to profiling and exclusion, and very big challenge is about the way it embeds. This becomes more concerned when automation can obscure discrimination by embedding it in systems that appear neutral, efficient, and even benevolent. Public trust in the proposed objectivity of AI can reinforce perception, making exclusionary outcome appears legitimate rather than contestable. The real danger lies in the veneer of neutrality, which renders discrimination less visible and significantly more difficult to identify, challenge the remedies. Then this question relating to the burden arises. Who is responsible if a system is put in place for distribution of goods and services? Where are you going to pin it? And then the remedies of addressing a problem where any one of these about goods and services or matters related to privacy are brought to the court, and how remedies are to be formulated. Then liability is also yet another thing, and this is an interesting feature. The challenge lies in determining where liability rests, whether with the developer, the developing institution, or the professional relying on the system. The difficulty to identify the problem exists. The challenge, therefore, is to identify these risks at the earlier stage, to design appropriate safeguards and ensure that technological adoption strengthens rather than compromises the normative commitments to legal These are some of the very serious concerns. There are therefore certain inadequacies that we must deal with. So we need to perhaps reformulate the existing structure of rights and also redesign or prescribe some conditions before these algorithms or LLM models are put in place. I believe that reimagining human rights in the age of artificial intelligence does not call for abandonment of existing rights, but their careful adaptation. I just indicate to you what could be such rights without going into the detail. One is that I have indicated that there is definitely a need for a right to explanation, how a system has operated. Then data autonomy or informational self-determination as the second one, right against algorithmic determination. Then we have formulated indirect discrimination while interpreting Article 14. It happens with the application of AI. It is intended to work or to benefit one, but consequentially, I'm not going into the details of it, consequentially, it will have its adverse effect on somebody else. So that is also an important facet that we must deal with when indirect discrimination occurs by the operation of AI. And we will have to reformulate the principles of burden, how we are going to require the concerned party to answer the violation of the right. Yet another feature is as the system is completely in the hands of either the developer or the person who applies or even the system, and we are all outside of that system, the obligation to detect, the obligation to see whether the AI system is operating without causing any harm is not in the recipients, it is in the hands of the maker. So therefore, we must construct a new principle that the obligation to correct, audit regularly is on the person or the institution or cumulatively on those who are putting the system in place. And I have indicated to you in the beginning that AI system must be operated ex ante. It is not after its implementation and the consequence having been faced by some of those petitioners, so to say, that you start looking at about the legality or validity of it. The real power that we can hold is to prescribe ex ante regime, and that ex ante regime is at the stage when somebody is asked to formulate an LLM for them or to design a product of distribution beforehand. So it is at that inception level that there is a requirement that there must be ethical standards. Somebody would scrutinize, audit the AI, and then approve it in a manner that it is safe for its implementation. These are all cases where we are talking about remedies. As we put AI into operation, we want to know that there must be a prevention of misuse, and at the same time what best remedies are available to us if something goes wrong. Today, I think we can recall Ambedkar's statement in the Constituent Assembly, where he said, rights are nothing unless remedies are provided, whereby people can seek to obtain remedies when rights are involved. I have spoken to you about the principle of inception. I have also indicated to you that accountability is a very important facet. There must continuously be what's called oversight mechanisms. UNESCO recommendation on ethics and AI is a very important document. They have indicated the features that are necessary in times to come to ensure that human rights are not violated. There is also UNESCO toolkit on AI and rule of law for judiciary, which also indicate what steps need to be taken by courts. Supreme Court also has formulated initially, and we are going to formulate yet another. We're going to release this shortly, the new formulation on AI. So in conclusion, I think I could read those 4 or 5 facets which are very important. AI cannot be expected to correct deep-rooted flaws in human decision making. This makes it essential to address bias at the level of design, data, and deployment rather than treating it as a downstream problem that technology is automatically resolving. Incomplete, inaccurate, or irreversible data should never be fed into AI systems. We need institutional guardrails. These can include mechanisms such as audits and continuous feedback loops, which allow systems to be evaluated not only for technological performance, but also for their social impact. Those affected by AI must have avenues to question, critique, and influence its operations. There is also an important aspect of ethical oversight. An AI system cannot be treated as an afterthought or left solely to technical experts. Every AI ethics committee should include review by a committee offering plurality of thought and judgment, as ethics risks are often qualitatively different from technical or legal issues. Designers, engineers, and data scientists may focus on functionality of performance, while jurists may be engaged once the dispute arises, but ethics committee must identify normative concerns at an earlier stage before they become embedded in the systems. Furthermore, we need independent regulators with investigative and enforcement powers alongside processes that enable stakeholders' participation in public deliberation. Transparency, democratic engagement, and accountability shall bring legitimacy to AI governance. In other words, we need systemic approach that provides assurance about the overall trustworthiness of algorithmic systems, especially where such systems directly or adversely affect individual rights. What then is the purpose? We can't deviate from the purpose. For what purpose are we employing AI? The most importantly, we must begin by reimagining the purpose of AI. The purpose of AI should not only be to collect data and give outcomes, but also ensure that such data analysis is solely for the betterment of the society. Nothing more. Instead of asking only how to regulate AI harms, we must ask where and how AI should be deployed in ways that address interconnected issues of social economy and even climate justice. Yeah, is there. I'll skip some more, and my conclusion is this. The contemporary movement invites a return to the foundational impulse of human rights project. In the mid-20th century, human rights engaged as a response to visible and centralized forms of power. Today, the power has assumed a different form. Just as earlier generations responded to the conditions of their time, we are required to recognize the emergence with new configurations of power. In doing so, institutions must ensure that the integration of artificial intelligence does not dilute their obligation to secure rights, but instead reinforce principles of inclusion, fairness, accountability that remain at the core of human rights. I will end this with an excerpt from a Swedish-American physicist, Max Tegmark's book. His book is titled Life 3.0, Being Human in the Age of Artificial Intelligence. As AI is likely to give us both grand opportunities and tough challenges, a strategy that's likely to help with essentially all AI challenges is for us to get our act together and improve our human society before AI fully takes off. We are better off educating our younger to make technology robust and beneficial before ceding great power to it. We are better off modernizing our laws before technology makes them obsolete. We are better off resolving international conflict before they escalate into an arms race in autonomous weapons. We are better off creating an economy that empowers prosperity of all before AI potentially amplifies inequalities. We are better off in a society where AI safely reaches results get implemented rather than ignored. Thank you very much. Thank you. Thank you for being here.
Thank you, sir. Thank you for this insightful lecture. And I believe that the crux of it is that AI is overtaking over and the rising empire of AI is invisible. And that is why there's a need of not only regulation, but also self-regulation. As there is a famous joke amongst the lawyers that there are two types of lawyers, one who use AI, another who lie that they don't. So with that, I would now like to invite Rajiv Datta, Senior Advocate and also Vice President of the Nivaaran, to make the concluding remark.
Justice Narasimha, Mr. Jaideep Gupta, Mr. Vikas Singh, Ms. Nandini Gore. Sir, all that I can say today is that it was a privilege listening to you on a topic which you yourself said was something which is new. It's also a difficult one, but it is something that we have to do now so that we learn more about it, because as the world is progressing, it is catching up so fast that every day we hear something or the other regarding AI affecting our lives. Soli Sorabjee fiercely defended human rights. And artificial intelligence, if it can support what he did, it will be a great task. As you said, we are learning new things every day. But there has to be a balance, sir. And you put it very well that you related it to our constitution, to Article 39, to Article 21, elementary education, privacy, deep fake, etc., etc. I think it was a master class, and at a juncture where we all need to get a deeper understanding. Thank you very, very much, sir. And I think it is will be our privilege also to get a copy of your lecture and distribute it to whoever would like to go through it.
AI will do that.
AI will do it. Yes.
AI will do it. I think they are already done it now. Now a little bit about Soli Sorabjee because I just cannot refrain from telling you that I had a privilege of not only working with him but working with him very closely on for a very long time. I met Mr. Sorabjee in 1977 when he became the Additional Solicitor General. I was dabbling with the Solicitor General, and almost every day we encountered each other. I thought the essence of what Soli portrayed was enjoy when you can, endure when you must. Soli's mojo, according to me, was his attractive personality. He was a man of all seasons. He loved music, jazz. In fact, I was responsible for organizing a jazz yatra in Delhi when I was in close contact with him. He used to play the clarinet. It's a single reed instrument, and also he was invited to play it on the radio. Soli used to write regularly, conveying his thoughts to everyone. His last piece that I remember that he wrote was in a newspaper on 18th of May 2020. He was a serious person, but did not suffer from what I call a disease of seriousness which has affected many people. They always pretend that they are serious. He wasn't like that. He had a tremendous sense of humor. If I have to tell you episodes and instances when I and Soli went through certain times, it will take the whole evening. But I must tell you that Soli enjoyed his food, his company, and his glass of wine. So, ladies and gentlemen, he also liked to mimic. And I can remember one small thing that used to happen when I used to visit his chamber. It was almost every second day or third day. In the morning at 8:15 or 8:30 in the morning before coming to the court, we used to brief him. I had this habit at which I never noticed, but he noticed, that whenever I went into the chamber with three of his juniors sitting there, the moment I saw him and he had the brief in his hand, I used to immediately start by saying, "Sir, this is a very important case." So as soon as I used to enter his chamber later on, as soon as I used to enter, he used to say, "Here comes another important case." Soli's sense of humor was absolutely par excellence. He was free from pomposity, self-righteousness. He was equally home with old and young. Raw juniors. He was very comfortable with raw juniors. He was also very unhappy in his later days about the cash mentality which has overtaken our legal profession. Unaccounted fee in cash and in other forms. So basically, I think what Mr. Sorabjee deserved from all of us is to always remember him. And every year we hold this lecture. And I'm very grateful to all of you for taking out this time to come here. And also, Justice Narasimha, as I already said, he dealt with a topic which was difficult, lengthy, and yet he made it he narrated the whole thing in a very comfortable way. And I saw that all of you listened to it with apt attention. Lastly, I have to thank the organizers for organizing this function, and also the CLA and Nivaaran for organizing this function. Thank you very much for coming, all of you.
कॉन्फ्रेंस से जाना है Thank you.
Thank you.
Tarun is here.